భారత న్యాయ వ్యవస్థలో కొత్త శకం ప్రారంభం కానుంది. నేర న్యాయ వ్యవస్థలో సమగ్ర మార్పులతో కొత్త నేర చట్టాలను కేంద్రం తీసుకొచ్చింది. ఈ చట్టాల్లో నిందితులకు శిక్ష విధించడం కన్నా బాధితులకు న్యాయం చేయడానికి ప్రాధాన్యం వచ్చాయి. జూలై 1 నుంచి అమల్లోకి రానున్న ఈ 3 చట్టాలపై అవగాహన కల్పించే లక్ష్యంతో హైదరాబాద్లోని కేంద్ర సమాచార ప్రసార శాఖకు చెందిన పత్రికా సమాచార కార్యాలయం PIB పాత్రికేయులకు వార్తాలాబ్ పేరిట శిక్షణ శిబిరం నిర్వహించింది. నల్సార్లా విశ్వవిద్యాలయం వైస్ ఛాన్సలర్ శ్రీకృష్ణదేవరావు, సెంట్రల్ డిటెక్టివ్ ట్రైనింగ్ ఇన్స్టిట్యూట్ CDTI డైరెక్టర్ N రాజశేఖర్ IPS, ఏపీ పోలీస్ మాజీ ఇన్స్పెక్టర్ జనరల్ E దామోదర్ IPS ఈ శిక్షణ శిబిరంలో పాల్గొని ప్రసంగించారు. ఈ సందర్భంగా శ్రీకృష్ణదేవరావు మాట్లాడుతూ దేశంలో క్రిమినల్ న్యాయ వ్యవస్థను బలోపేతం చేసే లక్ష్యంతో కేంద్రం భారతీయ న్యాయ సంహిత, భారతీయ నాగరిక సురక్ష సంహిత, భారతీయ సాక్ష్య అధినియం అనే 3 కొత్త చట్టాలను 150 ఏళ్ల నాటి బ్రిటిష్ కాలం నాటి చట్టాల స్థానంలో ప్రవేశపెట్టిందని చెప్పారు. భారత శిక్షా స్మృతి IPC 1860, క్రిమినల్ ప్రొసీజర్ కోడ్ 1873, ఇండియన్ ఎవిడెన్స్ యాక్ట్ 1872 స్థానంలో ఈ 3 చట్టాలు జూలై 1 నుంచి అమల్లోకి వస్తాయన్నారు. ఈ చట్టాలు శిక్ష కన్నా న్యాయంపై దృష్టి సారిస్తాయని, బాధితుల కేంద్రీకృత న్యాయాన్ని నిర్ధారిస్తాయన్నారు. విచారణను వేగవంతం చేయడం ద్వారా సత్వర న్యాయం అందేలా చూడటానికి కాలపరిమితి నిర్ణయించినట్లు శ్రీకృష్ణదేవరావు తెలియజేశారు.
I appreciate and congratulate PIB for creating this learning. In fact, as a teachers, learning is a first mantra for us. Generally, all of us, we don't pay much attention to learning. We think we have already learned. Three new criminal laws provided an opportunity for us to learn, relearn, unlearn. In fact, I'll start with this. Then I was just going through this wonderful booklet prepared by the PIB in Telugu language, because there's a lot of dissemination is required in understanding and analyzing the 3 new criminal laws. Let me start with this title they have given, Bhasha Punarujjeevanam Bharatiyatku Pedda Peeta. I really appreciate, because if you look at the colonial, what we speak about colonial remnants of colonial legacy we speak about, and whether in the nomenclature, Indian Penal Code, Criminal Procedure Code, Indian Evidence Act, I must appreciate whoever has suggested the nomenclature, Bharatiyata. Bharatiyata is something which really conveys a national interest, cutting across political parties. I think that we should first. So if you look at even the naming, that's what the Bhasha Punarujjeevanam Bharatiyatku Pedda Peeta. I have read several of the analysis, but the first time I must appreciate Shruti ji and other colleagues for identifying. That conveys what is the tone and tenor, the language, phraseology. I think that's not just only a symbolic, but if you see inside the definitions, you will understand. So that's what first I wanted to begin with, really that language played a clear role. If you look at Bharatiya Nyaya Samhita, Bharatiya Nagarik Suraksha Samhita, Bharatiya Saksha Adhiniyam, it's an attempt to look at the language as an important thing. Let me look at brief background and then go into very briefly 3 criminal laws. Indian Penal Code, we know 1860, amazing piece of legislation, but it has not comprehensively amended. Only what we say is a piecemeal approach. I'll come to that. Indian Penal Code, best part of Indian Penal Code even now, which is continued in BSS, is first it defines an offense, then in one section, and provides the punishment in another section. So that's one. Criminal procedure, I'll come to that little later, and then Indian Evidence Act. These laws signify a comprehensive initiative aimed at the overhauling the criminal justice system in India through the infusion of transparency, accountability, efficiency, and modernization into their provisions. These 3 new criminal major acts not only marks a paradigm shift, but also lays the foundation for a legal framework that is just, responsive, and aligning with the contemporary expectations and requirements of the Indian society. As I said, what happened before this three new criminal laws came into effect, which is going to come out from 1st July 2024. We have seen, I think the first instance is Criminal Law Amendments Act 1983. All of you journalist friends may be knowing Madhura rape case in 1973, first time criminal law amendment. That was a rape incident in Nagpur in a police station, and that resulted first time amendments to IPC, CRPC, Indian Evidence Act. Similarly, Nirbhaya case amendment, criminal law amendment 2013, and we have seen landmarks verdicts, and then Justice Verma committee, that's the second one. Then we have seen landmark work is the Indian Supreme Court, D.K. Basu. D.K. Basu, as a prevention of the custodial deaths, custodial violence, completely has. In fact, when I teach criminal procedure code, some of you are interested if you look at the old section 41 CRPC, where the police can arrest without a warrant in cognizable offences, and look at after the DK was amazing. So these are all piecemeal approach. First time a comprehensive reforms have started. So in a departure from such previous practices, the recent overhaul has replaced all the three major criminal laws in their entirety. The reform places significant emphasis on the seamless integration of forensic and digital technologies into the criminal justice. With the globalization, with the developments in information communication technology, I think all these new recent developments have. In fact, that's what olden days when we are speaking, I remember in Hyderabad several press conferences, we used to say that the best scientific method of investigation is crime to criminal. That is what is reinforced now. Moreover, the new courts have eliminated the references to several archaic, colonial remnants, Victorian provisions, and reflecting a commitment to modernization and efficiency in aligning the legal framework with contemporary trends. I'll briefly analyze key changes after giving this background into BNS, BNSS, and BSA. As I already said, the Bharatiya Nyaya Samhita, old IPC, is a catalogue of offences and punishments, and it defines a offence in one section. That's what the criminal lawyers always play on. What is the offence? Whether it is constituted prima facie offence. Definition is very important. Punishment is later. So Bharatiya Nyaya Samhita is a substantive criminal legislation. Apart from modification to the organization of provisions, several substantive areas. First is consolidation of similar provision. If you look at the old 511, now it is brought to 358 sections. How they have consolidated? It consolidated various provisions relating to the same offences, such as section 317 of BNS consolidates all the provisions relating to stolen property under IPC, which were set down in several sections. Similarly, provisions relating to three inchoate offences, attempt, abetment, conspiracy, have been brought together under the chapter 4 of the BNS. So this is the method which is used in the new criminal laws, particularly the Indian Penal Code, consolidate them together and remove old archaic provision. Second, gender neutrality. You know, the women's movement, feminism, has started questioning the criminal justice system all over the world in India. Where is the gender neutrality? Gender neutrality has been brought. Efforts have been made. Efforts have been undertaken to promote gender neutrality in criminal laws by expanding the definition of the term gender. Additionally, several offences, including voyeurism, assaulting someone with the intent to disrobe, have been made gender neutral. All the offences against women and children have been brought under Chapter 5 of the BNS, which is followed by offences against the human body. That is also prioritizing the offences. So women and offence against children have been given the priority. Another commendable aspect of BNC is, as I already said, removal of remnants of colonial references and archaic language. BNS uniformly uses sensitive language. It used the terms and expression child in the place of minor, child under the age of 18 years to the instead of child under the age of 18 years, child in all places. Persons with unsound mind in place of insane, lunatic, idiot. These are all the old provisions. Language also important. Age parity, they have been brought. Girls and boys stemming from the socio-political conditions of the 19th century has been appropriately rectified by the BNS. The age criteria for kidnapping victims has been standardized at 18 years regardless of the gender. In the light of the Supreme Court Indian Thought versus Union of India in 2017, the age bar under the clause has been finally raised to 18 years in the text of the law, as well as the amending exception to clause 63. Offense against human body. The offense of attempt to commit suicide has been removed from the BNS. First time a new category of murder is added that is called as a mob lynching. It criminalizes and provides punishment for murder, grievous hurt by group of 5 or more persons based on the victim, race, caste, community, sex, place, birth, language, personal beliefs, so and so. Key changes is in punishment. And that's what Justice Krishna Iyer long ago has said. What is this criminal justice system? Reform, rehabilitation, resocialization. I think that you could see first time community service has been given a priority, introduced, of course, in 6 minor offenses. First time offender, that's again they have been given. In fact, in 2022, Indian Supreme Court has suggested all high courts in India look at the 3 approaches in the punishment. What is that? Probation, plea bargaining, and compounding of offenses. In fact, that Supreme Court in the judgment has also said all the high courts now you do research. How do we use that? That's a major area. I think that somewhere it is mentioned in the community service is one, but this is major issue we could look at. Significant modification is evident in the BNS, wherein there is an overall increase in the severity of punishment, particularly in terms of fines. Fines have been. That's again a trend all over the world, tartification of criminal law. Instead of punishment, we have seen more and more fines and other, so that you could see punishments have been, fines amount has been increased. The debate on whether the right to life includes right to die has concluded with the BNS, which no longer criminalizes attempts to commit suicide. It's gratifying to observe that this progressive perspective has also been integrated into the penal statute. New offenses like sexual intercourse by deceitful means on the pretext of false promise to marry or employment has been added as an offense. Hit and run has been added. Now later they have changed it. Organized crimes, terrorism has found place in BNS. BNS retains the essence of the offense of sedition as acts endangering sovereignty, unity and integrity of India. Let me move to the CRPC, which is called as the Bharatiya Nyaya Suraksha Samhita 2023. Criminal procedure is another important law. You could see number of changes have been suggested, revisions and review in CRPC. Criminal procedure is an important law that underscores the importance of fair, just and reasonable procedure which is integrated into the criminal justice system. The majority of the changes in the Bharatiya Nyaya Suraksha Samhita can be categorized as a move towards 21st century by integrating forensic science, information communication technology, and the latest audio-visual electronic means in the investigative process. This is aimed at increasing transparency and accountability. By recording all aspects of the criminal justice process, including searches, seizures, FIR, statements, trials, BNS aims to create a more reliable and trustworthy system. And similarly, BNS has brought to make the investigation process more robust and efficient by introducing under section 176 class 3 to the BNS. It has been mandated that forensic team must visit the site of crime and collect the relevant forensic evidence. Wherever the police receive information about the commission of offense, if it carries a punishment for 7 years or more. Forensic science is a very important. We have seen in several cases, forensic science is the best possible. Of course, the doctor who gives, whoever is the expert, we call as expert evidence, they will be called to the court. So this is one. Videography of the entire procedure is another innovative method which they have suggested in the BNSS. Zero FIR, this is the first time. We know that generally the police officers will speak much more about this, but we know that when we go register an FIR, ये मेरा इलाका नहीं है, दूसरा इलाका जो, ये मेरा इलाका नहीं है, दूसरा. This is a general trend. This zero FIR, which is significant the first time, which as a discussion was there. What is the zero FIR? Significant alteration concerning the registration FIR is the codification of zero FIR concept, making it obligatory for police station to register an FIR upon receiving information about a cognizable offense, regardless of jurisdiction. The zero FIR concept was first introduced Justice Verma Committee recommendation, which is set up in 2012, pursuant to that infamous Nirbhaya case. Zero FIR can be filed in any police station irrespective of its jurisdiction. Subsequently, the concerned police station must transfer the zero FIR to appropriate jurisdiction to investigation. Next, power to postpone or adjourn proceedings curtailed, not more than 2 adjournments in the trial. I think this is necessary, and also that we need to now search for alternatives to the criminal justice system, and also how speedily we can resolve the criminal cases. That was a long pending Justice Malimat committee, Professor N.R. Madhavamenon committee, several things they have come out, but we need to, this is the right time and we have to do that. That is, under the section 309 CRPC, court had unlimited power to grant adjournment. In fact, the research studies all over the world have done, they have clearly said, if a court says, I am not going to give an adjournment, the mindset will be set up in the lawyer and the client. Ye to nahi de dega. He will not give. Manaki court ki ellina kuda okka adjournment ivvadu. That mandate has to come. That requires a lot of training of the judges and other, but not more than 2 adjournments. Protection of interests of the victim. We have been discussing for many years. In fact, Justice Krishna Iyer itself, long ago, he said, criminal justice system has a soft justice syndrome towards the accused. We have started looking about the victim. Where is the victim in the criminal justice system? Of course, accused, rights will be there, and victim also will be there. Never the victim will substitute an accused. That's a fundamental principle we all know. But protection of interests of the victim have been clearly mentioned. I think that's some of the progressive measures they have used. I'll give one example. Withdrawal of prosecution is a much abused. Section 321 of the old CRPC, now they have said about section 360 of BNSS. You withdraw. And withdrawal of prosecution earlier with the consent of the court and the lawyer and other. Now they have said even the victim has to be heard before you withdraw. That's the first time which is introduced. What it says, section 360 of BNSS now provides that a withdrawal can only be done after giving the victim an opportunity of being heard. The police officer is required to update the informant or the victim about the investigation progress within 90 period. Time frame is there. This is a real challenge now to all police officers, forensic, judges, prosecution, probation, all have to really learn and really work with a mindset. Then only we will move towards a real justice, fair and justice system. Witness protection scheme. We have been discussing about witness protection is stipulated. Each state government is required to formulate and announce witness protection scheme. Introduction of express timeline. We have been said 1973 CRPC, several Malimat committee, everybody said this investigation has to be speedy, trial has to be speedy, charge sheet has to be. Now they have fixed up specific timelines for every procedure. Let me move to the Indian Evidence Act, which is called as Bharatiya Saksha Adhiniyam 2023. Evidence can be a make or break in most cases. That's in the entire criminal law. IPC, CRPC was exactly burden of proof. How do you prove? First time, several of these digital evidence has been incorporated into this. It expanded records to include information stored in semiconductor, memory or any communication devices, smartphones, laptops, including records on emails, server logs, smartphones, location evidence and voicemails. Traditionally, oral evidence is included in statements before the courts by witnesses concerning a fact of inquiry. However, in the light of technological, it has given, even the BSA allows oral evidence to be given electronically. I'll just close with 2-3 and then we will hear both of them. And joint trial refers to because several of the cases what we have seen, one of the accused is absconding and the case will be stopped. So how do we promote that? How do we look at that? Some of these have been suggested, but digital evidence which has been clearly has mentioned. Another one it is also mentioned is that documentary I have mentioned about it, electronic records. Expanded the secondary evidence to include oral and written admissions and the testimony of a person who has examined the document and skill to examine the document. Let me conclude that there are positive measures and progressive amendments which have been discussed and debated for many years that found a place in the 3 new criminal acts. large part of the text of the existing legislation is carried forward in the new laws, because people are seriously, lawyers, judges, police officers, everybody is thinking, how do we implement it? So there's nothing much has been done except some progressive incremental provisions and changing the phase of the criminal justice system. But large part of the text of the existing legislation is carried forward in the new laws, and therefore the concerned journalists, advocates, students, judges, police officers, and all of us, those who are concerned in the criminal justice system, may not find difficulty in understanding and promptly implementing it. The primary intention is to restructure and consolidate various provisions in order to provide holistic understanding. It paves the way for contemporary criminal justice landscape which meets the needs and aspirations of the Indian society. Thank you.